page number 170. The de facto complaint argument and the council's labor was only on the aspect that it's necessary, it is enough for a complainant to merely write the names or say merely write a line that they have taken a check and that no specific government is necessary. But that mere reference to the name and writing also is absent in the complaint. Assuming but not admitting that there is some stray line, may I kindly request page 170, judgment 2025 7 SEC 393. Yes, Manoj, Kamal Kishore. This is as latest as Manoj, 13 February 2025. Paragraphs 15 to 18 Manoj. I would only request this court to consider paragraph 15, analysis under the heading analysis and findings. Particularly, my lords, on page 175, extracted paragraph 39, but may I just request from 15 onwards. This court in National Small Scale Industries versus Harmeet Singh, section, observed at para 13, section 140, may I proceed, minutes? Yes. Section 141 is a penal provision in creating vicarious liability and which as per settled law must be strictly construed. It is therefore not sufficient to make a bald cursory statement in a complaint that the director added as an accused is in charge of and responsible to the company for the conduct of the business of the company without anything more as to the role of the director. But the complainant should spell out as to how and in what manner respondent number 1 is in charge of or was responsible to the accused company for the conduct of its business. This is in consonance with strict interpretation of penal statutes, especially where such statutes create vicarious liability. Now, let's may just move to para 39. From the above discussion, the following principles emerge. 1. The primary responsibility is on the complainant to make specific averments as are required under the law in the complaint so as to make the accused vicariously liable. For fastening the criminal liability, there is no presumption that every director knows about the transaction. When this latest judgment holds the field with such clear language and ratio, referring to a judgment called SP Money which has been distinguished, it's in all due respects. The other small Roman number 2, 3, 4 and 5 also they assume significance. Lordship so permit, allow me to give a quick read of it. I'm given to understand that today we may have to raise early. So therefore, section 141 does not make all the directors liable for the office. The criminal liability may be fastened only on those who at the time of commission were in charge of and were responsible for the conduct. Vicarious liability can be inferred against a company registered only if the requisite statements which are required to be averred in the complaint / petition are made so as to make the accused therein vicariously liable for the offence committed by the company, along with averments in the petition containing that the accused were in charge of and responsible for the business of the company and by virtue of their position they are liable to be proceeded with. Paragraph 3. 4. Vicarious liability on the part of a person must be pleaded and proved and not inferred. Now this is important. What the complainant now is trying to do, is the inference part. This pleaded and proved is absent in their complaint. The primary responsibility lies on the complainant. This entire set of judgments which are before this court, they were taken into consideration by both the learned judges in the respective 845 and 847 odd judgments. I wouldn't wish to trouble your lordship with all of that. That is the reason in the index column itself, I have given the citation and the relevant paragraph numbers. What necessitated me to refer to the judgment of Kamal Kishore at page 170 is this particular portion and observation of the Honorable Court, which clearly lays down that the primary responsibility is on the complainant. Rest of the judgments have been taken into consideration, and that is how those two petitions were allowed. Now, my lords, if I may just quickly refer to the judgment of SP Money, which my friend had. This was distinguished in 2020. May I just pass on? Quote of here. This is not part of the SP Money card. Patent. For this 2023 8 SEC 473, may kindly request minutes on the second, the overleaf. Yes. The second, Lordships would find at Placetum E. Lordships would kindly find at Placetum E, SP Money and Mohan Dairy versus Nehalata Elangovan, distinguished on facts. The relevant paragraphs numbers minutes 8 to 11. Para 8. Now we come to the averments made in para 7. Firstly, it is stated that all the directors were liable for the transactions of accused one company. Secondly, it is stated that all the accused were fully aware of the issuance of the checks subject matter of the complainant, and they were also aware that the checks will be dishonored. Further, it is alleged that all the accused knew that there were no funds in the account of accused one company. Subsection 1 of section 141 of the NI Act required the complainant to aware that the present appellants at the time of commission of the offence were in charge of and were responsible for the conduct of the business of the company. In the present case, all that the second respondent has alleged is that the appellants were liable for transactions of the company and that they were fully aware of the issuance of the checks and dishonor of the checks. Therefore, even if we decide to take a broad and liberal view of the pleadings of the complaint, we are unable to draw a conclusion that the compliance with the requirements of subsection 1 was made by the second respondent. The most important averment which is required by subsection 1 is that the directors were in charge of and were responsible for the conduct of the company. The appellants are neither the signatories to the check nor are whole-time directors. In these three petitions, all the three petitioners, they are not signatories. The decision on SP Money will have no application as in the present case. The statutory notice was admittedly not served to the accused. Obviously, the High Court has not adverted to the aforesaid two glaring deficiencies in the complaint. In the circumstances, the appeal must succeed and the impugned order is quashed and set aside only insofar as the present appellants are concerned. May I kindly request para 17 minutes. The averments made in the complaints which are the subject matter of these three appeals are identical. We are referring to the averments made in one of these three complaints. It is submitted the complainant is a proprietor doing business. Accused 1 is a private limited company. Accused 2 is chairman. Accused 3 is a managing director. Accused 4 to 7 are directors. Accused 2 to 7 are managing the company and busy with day-to-day affairs of the company, and all are managing the company and also in charge of the company, and all are jointly and severally liable for the acts of A1 company. In spite of writing this, Honorable Supreme Court holds that there is no specific averment and it is quashed. Even this iota of effort by the complainant is absent in the instant complaint. The complaint which is before your lordships now, which is assailed, does not read in this manner. It is far worse, if I may say so. Or it reads, my lords,